and welcome back to another episode of The Endgame, Insiders on Your Side, a podcast developed for senior lab executives by senior lab executives. My name is Melissa Butterworth, and I am your proud host of the Endgame podcast. I am so excited about today's episode. The title of it is going to be Show Me the Money, the true economics that make up a lab transaction. Now, this is just so exciting to me. Not only is the topic really a hot topic right now, but I have got such a special guest today, somebody who I greatly admire. I actually wore yellow today because every time I see her, I feel like sunshine. She's amazing. Her name is Christal Contini, and she is a senior partner with McDonnell Hopkins law firm. Welcome, Christal. It's so great to have you here today.
Thank you. I'm very excited to be here.
Yeah, before we get started, I love to share with our audience a couple of fun facts. And I have a couple of fun facts on Christal today. I just learned, like Jim Billington, the CEO of Versant, that Christal actually used to work at a Burger King. Oh, not a Burger King. Whoops, a Dairy Queen.
Close enough.
I knew it was something with a queen, but yeah. So Christal used to work at the drive-through at a Dairy Queen, which is where she first learned how to count change. I bet that was a pretty exciting job, Christal.
Yeah, the best part is that if the lid didn't fit on top of the ice cream, then I got to scoop it off into a separate cup, and then I would be able to eat it all day. So it was pretty wonderful.
Oh my God, I love that. Oh, that's pretty cool. Well, I also understand that you used to work at a golf course, which was like your ultimate favorite job, and you drove a fairway mower. What is that all about?
So it was the best job. We would start at 6 in the morning and we would be done by 2 in the afternoon. And I would cut grass and basically mulch all day. So I got to use all of the amazing equipment. So I rode the fairway mower, which is this huge lawn mower to mow the long fairways. And then I also used the greens mower to mow all of the greens, which actually the grounds crew chief told me that women are actually the best at that job because of our attention to detail and the ability to not be really aggressive with the grass. So we were able to drive straight lines and make the golf course look beautiful. So that was my favorite job.
That is so cool. Oh my God.
Yeah.
And I never knew that. Well, it makes sense that, I typically find that women are very good with details and can multitask. So that's pretty cool. Oh my God, that's great. Well, Christal is also in my second book that's published on Amazon called Clues. And I think it's pretty cool. I put some amazing women in this book, and I have such admiration for you, Christal. Thank you for agreeing to be in this book. But she is highlighted in here, and I just couldn't be more excited to have you here today. So let's jump right into our topic today, which is once again all about Show Me the Money. And it's about the true lab economics of a deal. And how this topic came about is Christal and I have worked over the years on a number of transactions. And what's really near and dear to my heart, being the CEO of Advanced Strategic Partners and running a lab-specific M&A firm, is that I always like to pride myself in getting maximum value for our clients. And it's not only about getting maximum valuation as far as price is concerned, but it's really also about finding the right corporate fit, right? And it doesn't just stop there, right? Transactions are much more about that. And that's what we're here to talk to Christal about today, because the transaction does not just end when it comes to the valuation, finding the right corporate fit. And Christal, I'm going to turn it over to you and let you kind of talk a little bit about that and give us your personal take on the importance of different aspects of a transaction and how they can affect valuation.
Sure. So I love working with Melissa because we work with these wonderful clients, and as part of the process, we get a letter of intent, and the letter of intent has this great purchase price in it, and then everyone gets very excited. And then I roll in and I'm also excited because I know that the preparation work has been done. The client's ready to go to market. They have a great offer, but then I have to remind everyone that you have to pay taxes. And so everyone kind of looks at me and they're like, yeah, but like, what does that actually mean? And so one of the things that Melissa and I like to do at the very beginning of the process is make sure people understand like what that purchase price number means. And we make sure that they also get involved with their accountant, because it is not just that, okay, you have this number on the letter of intent and that's what you get to put into your pocket. There are a lot of pieces and parts to that. And number one, and one of the biggest, is that you have to factor in what you have to pay Uncle Sam and what it ends up looking like after you pay taxes and after you consider the type of structure of the deal as how that will impact the taxes that you pay.
Yeah, I mean that's a really really great point, Christal. And it's something that we like to advise the clients early on to talk to their accountant, and then also to get a really good tax attorney, which I know McDonnell Hopkins, you all have some excellent tax attorneys that can help with that. Talk to us a little bit more about that. I mean, talk to us about pitfalls potentially of C corporation versus an S corp, or how the laboratory may be currently structured and how that will affect valuation.
Sure. So many laboratory entities are taxed as C corporations. Some also may be taxed as an S corporation or even a partnership. The thing about a C corporation is that for all of those buyers out there who purchase assets, which I would say a majority of the buyers do like to purchase assets because they get the opportunity to purchase the assets they want and leave the liabilities behind that they don't want. If you own a C corporation, one of the things that we need to look at from the very beginning is how that impacts your taxes. And so what will happen with a C corporation is there is a tax at the corporate level, and then there's also a tax when the cash gets distributed to the ultimate owners. So unlike with an S corporation and or a partnership where it is just one level of tax, a C corporation has two. And so if that's not something you're prepared for, it really is something important to talk about at the very front, because then your accountant can run the numbers and say, okay, this is what the end result will be once you pay taxes, and once you pay taxes at the corporate level, and then once the distribution is made, what it looks like for what each of the owners get to put into their pocket.
Yeah, that's critical. I know we've worked on a number of deals recently where that has been a very critical factor in the deal itself. Is there anything that lab owners who are currently structured as a C corp can do to avoid that? I mean, can they change the status, and how long do they have to be? Like, let's just say they change it from a C corp to an S corp. How long would they have to be in that position before they were able to sell?
So what I would advise is not doing it right before a sale. And I would suggest that one of the things we could do from a structure standpoint is we could try to push the buyer to purchase the equity of the business. A lot of times buyers don't like to do that, but they have done it in the past. And I think it usually is just a negotiation in terms of what are the liabilities, what is the tax impact to the buyer, because what the buyer loses by structuring the transaction as a purchase of equity versus the purchase of assets is the buyer loses the ability to step up their tax basis and essentially have the ability to amortize the business and have additional deductions as a result of purchasing the assets. So most buyers don't like to do it, but it is something that Melissa and I have negotiated with buyers in the past. And it really is the sooner we have this conversation in the process, the more likely it is we can negotiate and or try to understand if there are other things we can do to make it more tax efficient.
Yeah, no, that's a very, very good point. I think the overall message here to listeners is bring in your accountant early on and make sure you talk to a competent tax attorney to understand the intricacies of how the sale is going to affect your bottom line in your pocket in the end. Because while a deal can look really attractive, like we talked about, show me the money, at the end of the day, you're going to see a lot of that money disappear and, go to Uncle Sam if you don't do the proper tax, tax work up front. Talk to me a little bit about deals where you have seen rollover equity. And if a seller is willing to take some rollover equity in the transaction versus all cash up front, how is that taxed?
Yep. So some buyers, particularly buyers who are private equity backed, they like to try to incentivize owners to stay with the business post closing. And so, what a lot of private equity buyers do is they pay not only in cash, but as Melissa noted, they pay with equity of the buyer. So, it is really important as part of the process to work with your tax attorney and your lawyers to ensure that the rollover equity piece is tax deferred. And what I mean by that is that you are essentially contributing that equity, the equity of the seller in exchange for equity of the buyer, such that it is not taxed at the time of the sale, but it is taxed when the buyer sells its business in the future. So you would participate in that sale. And that's usually how people, they describe it as the second bite at the apple. I actually hate that term, but that's kind of the nomenclature that a lot of people use in the deal world, is because you get to participate in that sale. And that is when, in the sale of the buyer, that is when you would actually be taxed with respect to that rollover equity. You would not be taxed at the time of your initial sale. If you don't structure it properly, what ends up happening is you would pay tax on the receipt of that equity for which you didn't actually get any cash. You're just holding stock of the buyer or membership interests of the buyer. So whenever there's rollover equity, it is a great way to incentivize sellers to stay with the business. But we want to make sure that you get the tax deferred treatment on that rollover equity.
I mean, this can get really complex. I mean,
It does.
yeah, but you know what? I can't stress enough the importance of having, a legal firm who has done, laboratory transactions involved in a process so that they can really help you mitigate a lot of the pitfalls. And so I think that is just very, very important. I have a lot of sellers who want to use their own, local attorneys who they're friends with, but I heavily advise against that, because issues like what Christal's bringing up today can really end up affecting and impacting you in the long haul. So, Christal, talk to us a little bit more about what are some of the common purchase price components or norms that sellers should be aware of?
Sure. So another thing about that, purchase price number that you see in that letter of intent is that most transactions are what is called cash-free, debt-free. So the good news is when the sale closes, most of the time, you, the seller, get to keep all of the cash that is sitting in the bank account as of the date of closing. But you need to remember that in these cash-free, debt-free deals, you also need to transfer the business without debt. So any bank debt, any capitalized leases, any true debt needs to get paid off at closing. If there isn't enough cash in the business at the moment of closing, that's okay. It can be deducted from the purchase price paid at closing, but it will be a deduct to the purchase price. It is almost always cash-free, debt-free, because what the buyer wants to do is they want to have a clean balance sheet on the day that they close. No debt, and then they'll start running the business going forward so that they can generate revenue and generate additional cash.
Yeah, that's critical for sellers to understand, because again, it goes back to, we come to you with an LOI and it looks so exciting and it's got this big, huge number, but that number can quickly dissipate, not only with taxes, but also with existing debt that you may have on the book. So I think that is a really great critical point. Christal, talk to us a little bit about, what is an earnout or a contingent consideration? Because that term is used a lot, and we have a lot of sellers ask us, is it possible that we can also get a earnout or contingent consideration to help, drive that price up higher, number one, and number two, because we've got a lot of new business that we've just started, and we want to be able to get credit for it. So talk to us about what that means.
Yeah, so an earnout is a double-edged sword. It is best used when you're trying to bridge the gap or as Melissa was talking about, you have some new business that can't really be included in the full purchase price, and so what you're hoping to do is get credit later. So usually an earnout is paid post closing, based on post closing performance. And that performance needs to be clearly spelled out in the purchase agreement in order to ensure that you actually get credit for it. So it is contingent. You don't know if you're going to receive it. It usually makes the number look higher, but the devil is always in the details. I always say that there's one group that is always going to make money off of the earnout, and that is the lawyers, because we need to negotiate those terms on the front end to make sure you know what the hurdles are, to make sure that they are actual achievable hurdles. The best earnouts that Melissa and I have negotiated are those that are based on revenue, because it's usually pretty clear what the money is when it comes in the door post closing, so that you can get your percentage of what comes in. If we base the earnout on things like EBITDA or some other calculation, the buyer, you have to remember, is running the business now. And so their approach to expenses might be different from your approach to expenses. And so when we talk about what are the hurdles that need to be achieved post closing for you to actually earn your earnout in that extra purchase price, we really need to make sure we understand, like, what are those expenses going to be? Do we need to cap certain expenses so that they don't the buyer doesn't lever a bunch of expenses onto the business post closing to drive down your ability to meet the earnout? So it's a great tool. You have to understand how to use the tool, and you need to rely on the specialists to help you negotiate it so that they are achievable.
That is such a great point. I mean, having done this for close to 17 years, I've learned so much about earnouts and considerations, and I've learned that, like you said, the devil's in the detail. And it's a very difficult thing to make sure that you negotiate, and it's a very difficult thing for the buyer to track internally in a lot of cases. And so I think that you hit on a very, very crucial point, and it's another reason why sellers really need experts on their side to be able to help them avoid some of the pitfalls. Because I have to say, from my own experience, I've seen maybe 50% of the earnouts actually get paid out, and the other 50% not. I don't know, what percentage would you say on your end, Christal?
I would say that's a true statement. And the ones that often get paid out are the ones that have like a little bit of a ladder vesting, so that it's almost like you're sharing in the percentage based on performance. There are some earnouts that are structured a little bit, for lack of a better term, as an all or nothing. So I'll just make up some facts. You need to grow the business by $3 million worth of revenue. And if you grow the business by $3 million worth of revenue, you will get, $1 million of post-closing earnout consideration. I cannot tell you how many clients I have had that hit like 2.8 million, and they don't actually clear that $3 million revenue target. And then they end up not being able to share in any of that success just because they missed the hurdle by a small amount. And so it's the ones that have like a little bit of a progression where I see the clients more likely to at least hit some of the parts, if not the whole part, in order to get paid some contingent consideration post closing.
Yeah, I know that's a great example, and I appreciate you sharing that for our listeners. I'm sure they do too. That's a very, very good point. Talk to us a little bit about escrows and other holdbacks in a transaction, so that sellers understand when they get close to the finish line what they're actually going to have to leave behind to protect the buyer when it comes to reps and warrants and so on and so forth.
Yeah, so almost every transaction has at least one escrow, if not two buckets of cash that the buyer wants to sit, usually with a third-party escrow agent. If they want to hold on to the money, that's usually problematic when I represent the seller, because I would rather that those funds be held in a neutral third-party account. And so the reason the buyer wants to put money in escrow is to cover post-closing losses that relate to pre-closing running of the business by the seller. So I'll give an example. In a purchase agreement, the sellers will make a lot of representations and warranties about the operation of the business up until the closing date. And then the parties will close and the buyer will start to run the business. If it turns out that one of the representations and warranties made at the time of the closing turns out not to be true, and the buyer learns post-closing of that issue and experiences a loss, one of the common reps is the seller say, the seller has complied in all material respects with all laws. That's a pretty normal. The lawyers will have more words in there, but that's the general point of the rep. And if it turns out that the seller didn't comply with some healthcare law, or there was a kickback or something happened and the buyer has a claim relating to that pre-closing period, they will have the ability to make a claim against the sellers post-closing and essentially seek indemnification or reimbursement for their losses. The escrow is the first place that the buyers usually go because it's a pot of money available for these claims to recoup some of their cash. I would say most escrows for post-closing losses are about anywhere from 5 to 12% of the purchase price. So that impacts your cash at closing. So it gets reduced from the purchase price. It gets parked in that third-party account, and then it's available for the buyer post-closing. Most escrows are released between 12 months and 24 months after the closing. And if there are no claims, that cash gets to go back to the sellers. If there is a claim, then the buyer and seller will need to negotiate a settlement, or maybe it gets taken to court, which is a little bit more rare. And the escrow is available to fund the losses of the buyer.
Wow. It's so complex too. I'm kind of curious. Have you, would you say it's 50% of the time or 80% of the time that you see sellers actually get that escrow money, or what percentage would you say overall?
I would say most of the time sellers get their indemnification escrow back. The times where I see that they do not get their escrow monies back is when something kind of falls out of the sky that they really weren't thinking about. And, maybe a customer comes back and makes a claim, or if there's an investigation, usually it's pretty unusual. Almost always the indemnification escrow gets recovered by the sellers. I would say where I see the most claims are disputes about what's called net working capital at closing, and that piece is usually where there's a little bit of a dispute over what the closing balance sheet was at closing, and sometimes buyer will try to recoup some cash relating to that true-up process. But there aren't as many claims, which part of it is a function of the seller doing the work on the front end. If the seller has done the work on the front end and they know their business, it is less likely the buyer is going to be able to make a claim and take some of the cash from the escrow.
Yeah, I know that's a really, really good point. I would say in the majority of all the deals that we've worked on over the years, I've seen about 80%, 90% of the sellers actually get that escrow money back. And in cases when they didn't, it was really related to undisclosed liabilities and things that kind of came out of the woodworks. Like we typically see that sometimes. But I know we've covered a lot today. Before we leave, there's just one area that I just know the viewers are going to be so interested in hearing about, and that is, how often does a buyer actually renege on the sales price and either take that sales price down or up the sales price, right? Because it can happen both ways. Typically it goes south and goes down. But I've had that question asked a lot, and just from personal experience, typically what happens when we take our clients to market is we typically get a range from the buyers. Let's just say that, we're selling a lab and we've got multiple lab offers. Typically we see, let's just say it's between 37 and 40 million, right? Or 30, 38 and 41 million. Usually it's a $3 to $5 million range we typically see. And the reason there's a range is because the buyers are going out, going off of what we have presented to them in a professional sum. And that's basically what our sellers have provided to us. And so the buyers want to go into due diligence and take a deeper dive. And sometimes when they take that deeper dive, they realize that what they looked at and what they based the valuation of the business on does not always line up with what their expectations are. So in some cases, they will change that sales price. And we've seen it on our end occur, I would say, and usually it happens post due diligence. We've seen it happen maybe in about 30% of the cases, maybe lower, maybe 20% of the cases. We've only once have we had the price go up. That was only one time. It's not to say that it can't if you've got, legitimate reason, whether that's, new book of business came in and occurred toward the end of the due diligence period, then we've been able to negotiate additional back end money for them. But I'm curious to see your perspective, Christal. Have you seen a lot of cases where the number changed?
I think my experience is very close to yours, and maybe to your point on the purchase price going up. I have only seen a purchase price go up once before as well, so it is much more rare. Where I have seen maybe a little bit more give is in an earnout. So if there is that kind of scenario with a new book of business, I've seen it get pushed to an earnout. So at least there's that opportunity to get additional cash. Purchase prices going up down, I would say maybe 20% of the time. There are maybe one particular scenario where I see it happen the most often, and where due diligence uncovers some sort of legal risk relating to a transaction. Maybe there's an ongoing litigation, or maybe there is a claim that happens like right in the middle of the transaction. In those situations, either the purchase price gets reduced to cover that risk, or money gets put into a special escrow for the particular issue that comes up. But most of the time, what I see happen is a buyer will do enough due diligence to put forward the letter of intent. They'll have that range that Melissa just talked about, and then they will do some level of financial due diligence, and often what's called a quality of earnings report. It's after that quality of earnings report comes in that if we are going to hear of a purchase price reduction, it is usually after that report that the buyer does where we hear that there might be some level of a reduction. It would be pretty unusual after that, in my experience, to see any reduction, but it actually doesn't happen that often. And I think part of the reason, and for those clients who do the financial preparation on the front end, they already know what the hurdles might be. And then Melissa can, on the front end, address things that might show up in the quality of earnings report or might show up in financial due diligence. So the buyer is aware of them whenever they put the letter of intent forward. So they're not surprised, and then they don't try to reduce the purchase price because of the surprise. So it doesn't happen that often, but when it does, it's usually a lack of preparation, or something has happened on the legal side to cause the reduction. And then, the parties just need to deal with it as part of a negotiated process.
No, I mean, wow, Christal, you're amazing. I mean, you are such a breath of fresh air. I love working with you. Tell the viewers today how they can get a hold of you if they have any legal needs relating to their laboratory. Is it best to reach out to Christal Contini at McDonnell Hopkins, or what's your exact contact information?
Yep, it's C Contini, CCONTINI at McDonaldHopkins.com. And we specialize in laboratory transactions, but also in, I would just say, the general healthcare arena. And then we also specialize from an M&A standpoint in what I would just call, industry agnostic M&A as well. So I work with a talented group of professionals. We are deal lawyers. We work in the M&A space, and these are the issues we know how to deal with, and we love working with Melissa, and we hope we get more chances to do that.
Well, Christal, it's just been wonderful having you here today. I love working with your team. And I just know that the viewers have gained incredible insights and very valuable information. And for anybody who's just tuning in, if you would like to see this podcast again, it is located on our website at www.advancedstrategicpartners.com or Apple and or Spotify. And we are also now on YouTube, so you can check out all of our podcasts. I sincerely hope today has been very informative and educational for each of our viewers. And I am signing off as your host of The End Game. It's Melissa Butterworth, and I will see you in 2 weeks.